Mike, can I just intercede for 1 second on
Sure.
what you just said? It's very important about the opt-outs. Is please make sure that everyone consults with us. We're happy to provide you insight about that because there are a lot of ramifications about you opting out. We just want to make sure that you are protected.
Yeah, and I'm going to go over that in a little more detail in the next presentation. But so what happens if you do nothing? The do nothing option. If you are an adult and you're part of the class, that is, you have your own personal injury as an adult, or you're a property owner as an adult, or you're a business owner, and you do nothing. In other words, you don't register and you don't opt out, all of your rights against the state of Michigan, the city of Flint, McLaren Hospital, and Rowe Engineering will be extinguished. You will not be able to make any recovery against those defendants, and you will not be able to pursue your own case against those defendants. Your rights will be determined by doing nothing. So it's very important that you consult with class counsel or any attorney of your choice to make sure that you understand what it means to do nothing. If you do file an opt-out form, you will have a right to proceed with your own individual case against the state of Michigan, city of Flint, McLaren Hospital, and Rowe Engineering. But you can only do that if you're an adult, if you submitted a timely opt-out form. Let's go to the next slide. So if you are a parent or a grandparent or a representative of a child, you need to pay attention to the three options that are available to you as a representative of a child. So there is a part of the settlement that enables children from date of birth through age 18 on date of first exposure, which is April of 2014, to participate in this settlement program. And in order for the child to participate this year in the settlement program, a registration form will have to be filed on behalf of that child. If you are a parent, grandparent, or representative of the child, and you believe it's in the child's best interest to proceed with the registration, you should make sure that registration form and all supporting documentation is submitted by March 29th. Now, because children are not part of the class action and they have a separate section in the settlement program, if you as a parent, grandparent, or representative of the child wish to defer the child's participation in the settlement, you may do so. There is a form called Notice of Non-Participation, and under the settlement agreement, Judge Levy has asked you to fill out that Notice of Non-Participation. And what that means is that you have elected on behalf of the child not to participate in the settlement at this time. And that form should be submitted no later than March 29. Now, what happens to the rights of a child if nothing is done, if there is no registration and if there is no notice of non-participation? The children retain their right to proceed with participation in the settlement program on a deferred basis. And what does that mean? It means that up until the time the child turns 19, that child can submit a claim in the settlement program. $35 million has been set aside for the children who wish to defer their participation to a later time. And that is a right that is given to the children as part of the settlement agreement. And that money, $35 million, will be set aside from the settlement, and they will be available for children when they, if they wish to defer their participation in the settlement program at a later time. So that's a very favorable option that the children have. And if you are a parent or a grandparent or a representative of the child, you may want to consider that option for the child. And again, it's very important that you consult with an attorney to make sure that you are pursuing an option that is best in the best interest of that child. Sometimes it might make sense for you to wait. Other times it would be important for you to participate immediately. I would think for most children, immediate participation is probably in their best interests, but you have to decide as the guardian, the parent, or the grandparent, or the representative of the child, what's really best for them. It's a big obligation that you have as the adult, and you need to get proper advice to do that. And we at the Class Action Office, those of you who have retained us to represent children, we can certainly do that. So as Ted pointed out, there is this option of opting out that is excluding yourself from the settlement. Again, if you opt out or exclude yourself, it only relates to the claims against the state of Michigan, the city of Flint, McLaren Hospital, and Rowe Engineering. Does not, you still have all your claims against the two private engineering companies, Land and Veolia. And if you have already pursued a claim against the EPA, that claim remains in place, and your opting out was not going to affect your right to proceed with a claim against the EPA. So it's very important that you understand that we as class counsel, Mr. Leopold and myself and all the other attorneys who have worked to put the settlement together, are not legally permitted to represent you in a separate lawsuit against these settling defendants. If you wish to pursue your own individual case, for whatever reason you feel it's important for you to do that, you need to secure the services of another attorney. And if you wish to exclude yourself, it's very important, as we said in the highlighting area, that you should consult with another attorney immediately. And it should be a knowledgeable attorney, somebody who understands this case and what is happening here. Because if you decide to opt out, you're going to have certain obligations that are going to be required of you in order to successfully pursue your own individual case. Now, there are some risks involved in excluding yourself. One risk is that you're going to have to arrange for payment of legal services with another attorney. The way the settlement is set up, there are procedural requirements that are going to require you and your attorney to secure the opinions of expert witnesses on a pretty rapid basis. In other words, as soon as you file your case against the state of Michigan, the city of Flint, McLaren, or Rowe, there are going to be obligations to present to the court expert witness affidavits and reports, and those, of course, will cost money, and you will be obligated to pursue the procedures that are set forth in the settlement agreement. You should understand that if you file your own individual case, you will be held to strict proofs. And that means you're going to have to show that you or your child were injured as a result of exposure to the contaminated water, and that injury was the result of the exposure to the exclusion of most other causes. That could be very time consuming, very expensive, and in some cases virtually impossible because of the strict proof requirements that would attach to you and your attorney if you were to pursue your own individual case. And of course, if you elect to pursue your own individual case against these defendants, you may have to wait several more years before you get to a trial date or until your case is resolved. You should also keep in mind that there are certain time limits for filing individual cases. Some of those time limits may have already expired, and you need to consult with a knowledgeable attorney to make sure that if you want to proceed with your own individual case, that your case is timely and that you're going to be able to pursue it. So what we're trying to emphasize here is that you do have the right to opt out. Nobody's required to participate in the settlement program. We think that it's probably in everyone's best interest to give serious consideration to doing so. But if you decide to opt out, you should understand that there are a number of risks involved in doing so. I want to repeat something that's really important, and that is you cannot opt out and file a registration form. You have to make the election, and you have to make that election before March 29th. Keep that in mind. And as Trishelle pointed out, if you wish to object to the settlement, you can only do so if you remain in the case. If you opt out of the case, you will have no standing to file an objection with Judge Levy. The only way you can file an objection with Judge Levy is if you agree to participate. You file a registration form by March 29th, and then you will have the opportunity at that point to file an objection and also appear before Judge Levy at the fairness hearing on July 12th of this year. So I know this may seem a little confusing, but we are we were here to help you understand this, and we will do everything we can to make sure you make the best selection for you and your family. And feel free to contact us at the office. One of our attorneys will work with you individually to make sure you make the best choice for you and your family.